Supreme Court judgment.
Page 93.
Paragraph 54.
But we are with you for the time being.
No, Millets, this contention as urged by the learned Advocate General is emanating from the notification issued by NCT, which was quashed by the Supreme Court. That's what I'm trying to say. There is no question of making any concessions in this. 54, kindly have a look at.
54, yes.
Now, any person possessing such minimum qualifications as laid down by the academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. So the only authority to prescribe qualifications is NCTE. State can't meddle with it. State doesn't even have a power. They may have a bridge course for 2 years or 10 years. It doesn't make them eligible for being appointed as a teacher for elementary schools.
So who has the power?
Power, central government has conferred it on NCTE.
Now NCTE also supports B.Ed.
That was
passed by the Supreme Court.
And the NCTE is not talking about any bridge courses. That is what you mean to say.
They are talking about a bridge course.
Huh?
That is the circular itself that was set aside by the Honorable Apex Court.
And in the present case, the bridge course as is being suggested or online training or on-job training is not at all
Permissible.
NCTE.
It is not permissible at all. It runs
Anyway, so we'll give some time to the learned Advocate General. We'll take it up tomorrow, but in the meantime, don't issue hall tickets to B.Ed students.
One sufficient. Your hall tickets is anyways going to commence only on 22nd. For this reason, I'm indicating to your lordships.
From 22nd.
On
No,
22nd.
not tomorrow.
Not tomorrow. I'll only indicate so that
So
your lordship
tomorrow,
will come
we'll
to.
take it up tomorrow.
Because the bridge course that is being spoken of by the Learned Senior Council is not the same as the apprenticeship.
No.
These are two
There's
additional things.
There's one difficulty, Mr. Advocate General. When you said B.Ed, Supreme Court found fault with it, saying it is a different education. It's a different kind of training. And Supreme Court also went into the question of whether
Course can be a
which
substitute.
course can be substitute and said it is not a substitute. Effectively, it is not a substitute. In such a situation, whether it's whatever name we may give it,
This is what we are proposing subject to it. What we are proposing is 6-month bridge course, and in addition to that, a 2-year online diploma course.
This may not be
Very
on the job learning is
Very-
so these children are not to be experimented with by B.Ed.
Yes.
qualified,
in any event, even if we were to agree with you, we are bound by what the.
No, your lordship. No, as I am. So therefore, my lords, tomorrow, perhaps now that it's more or less over, your lordship may take it up regularly in the morning itself. Perhaps I'll conclude my submissions in the morning.
All-
Tomorrow, Mr. Arnandro may not be called upon to
Tomorrow, Mr. Learned Advocate General may as well concede in the
I would
morning.
be on his side if what goes.
Tomorrow morning, we'll take it up first case.
Very well.
I'm blessed.
Millets, looking at Mr. Sriram for all these 20 years, Millet, I have never seen him conceding a case. This is on the lighter side.
Well, my concession is also a little aggressive is what he's saying.